Ms. Whaley?
Thank you, Your Honor. Okay. Your Honor, my friend Mr. Wagner has just made the argument that the disinheritance clause is void on public policy grounds, and I concur with the position taken by my friend. If, however, you're not minded to agree with this position, then the alternative argument that I'm submitting on behalf of Howard today is that he qualifies as a dependent under Part 5 of the Succession Law Reform Act, and he is therefore entitled to an award of support in spite of the clause in the will disinheriting Howard for marrying outside of the Jewish faith. And in spite of my friend Ms. Charlebois' argument, I will be highlighting a few pointed arguments from my factum, Your Honor. It's my submission that Howard is a dependent of his father, and moreover, that his father had a solid legal and moral obligation to provide a proper share of his estate for Howard. My further submission is that the deceased did have a moral obligation both to provide a share of his wealth to his son regardless of need, and to morally support him, and his moral obligation translates into a legal obligation now that our provincial case law has developed to support this contention. Morally, the deceased was obliged to support Howard, including his choice of spouse, and the deceased should not be, now in his will and in his death, permitted to abdicate this moral responsibility. It is clear that as a result of the disinheritance clause that the deceased did not make adequate provision for Howard, since half of the residue of the estate will now pass to his sister Janet. Your Honor, I rely on Section 58 of the Act, which states, where a deceased has not made adequate provision for the proper support of his dependents, the court on application may order that such provision as it considers adequate be made out of the estate of the deceased for the proper support of his dependents. And further, Your Honor, I also rely on Section 57 of the Act, where the definition of dependent includes child, a child of the deceased to whom the deceased was providing support immediately prior to death or was under a legal obligation to support. Importantly, Your Honor, the Act does not limit the definition of child to a minor child, and nor does it limit the definition to financially dependent children. And as such, there is no question, Your Honor, that Howard meets the first part of the test. As to the second part of the test in Section 58, the right of an adult child who is receiving support immediately prior to death to receive support after death has been clearly established in Ontario. The deceased did provide Howard with support, and over the course of a long lifetime, immediacy irrelevant. Howard deposes, and his cross confirms, notwithstanding Mr. Vander Zee's failed attempts to discredit my client, Your Honor, that his father did his best to provide he and his sister with every luxury he could afford. Howard went to private schools, he went to summer camps, he traveled the world, all on Dad's account. Howard graduated, he went to Columbia University in New York, and the deceased supported him. He paid for the education that Howard received. And the tuition was very expensive. And he gave Howard money so that he didn't have to have summer jobs or employment during the course of his studies. The deceased assisted Howard by giving him $250,000 at the time he was setting up his business. Notably, Your Honor, support has not been limited to financial support in our Ontario case law, and nor in the factors enumerated under Section 62 of the Succession Law Reform Act, which, by the way, since the inception of that legislation, has provided as criterion a moral obligation. The cases of Davies and Cummings support the contention that support may also include physical and moral support. The right of an adult child who is not receiving support immediately prior to a parent's death until the Supreme Court of Canada case in BC, the case of Tatarin, was less certain. But now, according to the court, two interests need to be protected. The first, Your Honor, those of spouses and children, and ensuring that they receive adequate, just, and equitable provision and equitable division of the family wealth, even in the absence of demonstrated need. And the second interest to be protected is testamentary autonomy, which I'll touch further on in a minute, Your Honor, you having asked the question of my friend Mr. Wagner. In determining and reviewing the two interests, the court held that there must be an examination of the legal and moral obligation owed to the children. With respect to moral obligation, the court looked at obligations owing to independent children specifically, and importantly stated, while the moral claim of independent adult children may be more tenuous, a large body of case law exists suggesting that if the size of the estate permits, and in the absence of circumstances which negate the existence of such an obligation, some provision for such children should be made. And where the estate permits, all claims should be met, the court said. And though noting that the legal claims should generally take place over moral claims, this distinction is important, emphasizing a separate moral claim exists, therefore making it a legal claim. As a result of this seminal case, we have seen our provincial courts increasingly choosing to interpret our dependence relief legislation in such a way so as to attribute a greater weight to the moral considerations. And Ontario is no different. In Cummings in 2004, the finding upheld by our Court of Appeal, where it declared that the principles of Tataran applied in Ontario, and that's in spite of the differences between the legislation. In fact, the Court of Appeal went so far as to hold that a moral obligation is owed to the spouse and children on death, and with respect to claims made by adult independent children, the court held that the dependence relief legislation was not only to provide for need, but was also to ensure that spouses and children receive a fair share of family wealth. Notably, our court stated at paragraph 20, Your Honor, referring to Tataran at paragraph 40, a deceased's moral duty toward his dependents is a relevant consideration on a dependence relief application, and judges are not limited to conducting a needs-based economic analysis in determining which disposition to make. In doing so, the court rejected the argument that the judicious father and husband test should be replaced with a needs-based test. Essentially, the upshot of Cummings, Your Honor, is that it brought Tataran fairly and squarely to Ontario, clarifying that both moral and legal obligations must be considered, and even independent children are entitled to proper support and a fair division of a parent's assets after death. The Court of Appeal held that in determining support, the courts are to use their discretion to both identify and prioritize claims, and that where the estate is sufficient, all claims ought to be met. The court is afforded broad discretion in applying equitable relief. There has been further case law since Cummings supporting this position that adult independent children like Howard and Janet ought to receive a fair share of family wealth. For instance, I draw Your Honor's attention to the case of Broderick and Papathanassiou. This is a 2006 case in Ontario, and the court applying Cummings confirmed that whether or not the applicant was a dependent of the deceased should not be determined solely on a needs-based analysis. In making its decision, the court balanced both the legal and the moral obligations owed by the deceased to his children, and in this case his adult daughters, to enjoy the benefit of their father's estate. And the case of Pirelli and Foley estate, which provides support for the position that a moral obligation equates to a common law legal obligation. In that case, applying Cummings, the court concluded that the court must do more than conduct a simple needs-based analysis and determine the issue of proper support, and the court should apply the judicial father and husband test in determining the appropriate disposition. The court citing Cummings and Tataran for the proposition that the deceased's moral duty towards his dependents is a relevant consideration. And the Ontario Court of Appeal confirmed that one of the objectives of the Act was to ensure that spouses and children, again, receive a fair share of family wealth. The court did state it must consider the intentions of the deceased so as to protect testamentary autonomy. And I understand this is a concern of Your Honors, having asked my friend Mr. Wagner. In this case, for reasons submitted by my friend Mr. Wagner, the autonomy of the testator was exercised unreasonably and without regard to his moral obligations. The court also noted that in a claim under Section 58 of the Act, it must first identify all of the dependents and quantify and prioritize the claims, and to also identify those non-dependents who may have a legal or moral claim to a share of the estate, and then to balance those competing claims by taking into account the size of the estate, the strength of the claims, and the intentions of the deceased in order to arrive at a judicious distribution. The court found that the deceased clearly had a moral obligation in Pirelli to provide the bequests he did to his adult children and to provide for his spouse. And one other case, Your Honor, I'm not sure if anyone has addressed this today, was a case of Salmon and Stabler, and it's a BC case from the year 2000, where an applicant who was one of 6 independent adult children had been disinherited. The parties were all on an equal footing. The plaintiff's conduct towards his mother while she was alive did not disentitle him to a share of the estate, and the court ordered that he share equally in the estate of his late mother. So to conclude, Your Honor, there's little doubt that as a result of Cummings, Tataran has come to Ontario. Indeed, the deceased had a legal and binding moral obligation to provide a proper share of his estate to his adult children, even those self-sustaining adults like Janet and Howard. Applied to the facts before us, there are no circumstances, Your Honor, negating the obligation to provide for Howard. Although Howard did not adopt his father and his sister's new way of life, their family relationship continued. It did not change. They still loved each other. The deceased and Howard had only argued once in their entire lives. The estate is a large one. It's over $1 million. The only other dependent is Howard's sister, and her interest, too, is a moral one. She's not in financial need. The legislation permits, Your Honor, wide discretion to make adequate provision for Howard. Howard ought to be entitled to an equal share of his father's estate. It's my submission, Your Honor, that adequate provision in these circumstances should see the family's wealth distributed evenly as between Howard and his sister. That said, Your Honor, Howard, being a generous man like his father, would be content for the charity B'nai B'rith to receive its legal cost and a charitable donation from the estate, or alternatively from Howard and Janet equally from their respective shares, in the total amount of $100,000. Your Honor, those are my submissions, subject to any questions you may have.
Thank you, Ms. Whaley. I would have preferred a donation, I think, to the judge's pension plan, but that's fine. Are you saying to me, Ms. Whaley, that I am in a better position to determine what is fair and reasonable than Howard's father, than the deceased? Isn't that the position that you're putting this court in, that I am now the one who has to decide what is morally the right amount when the testator, if we have any testamentary freedom, isn't that their choice? Aren't they in the best position to make that decision?
Well, Your Honor, the testator is no longer with us, unfortunately. And because
I find that in many of these cases. It's a shame, really. It would make my job so much easier. But anyway.
And unfortunately, Howard is left in the position of having to, at great expense, come to Your Honor and ask you to assess all of the facts and exercise your discretion as you have to make an equitable and adequate award of support to him.
But hasn't the testator considered all those moral obligations? Why am I second-guessing the testator?
I'm not sure that he had good counsel when he did his will, Your Honor.
Thank you very much, Ms. Whaley.
You're welcome, Your Honor.